So in the previous lesson, what we did was talk about statute law as one of the major sources of the UK's constitution. In this video, we're going to talk about the next of the major sources of the UK's constitution, this being constitutional conventions. Now, we understand statute law as being relatively easy to get our heads around. It is the law that is made by Parliament. It is the kind of legislation that is passed through Parliament, through the House of Commons, and then through the House of Lords, and then receives royal assent. And essentially, that's really where it begins and ends. If you then attach to that concept of parliamentary statutes the idea of parliamentary sovereignty and the principle of parliamentary sovereignty, which we've spoken about as well, then you get really a full and a holistic picture of where Parliament sits in the broader context of the UK's constitutional framework. Conventions are a little bit more complicated, and they're a little bit more unique to A, the United Kingdom, and B, to this specific area of constitutional law. And so ultimately, we're going to be concerning ourselves with the idea of a constitutional convention, arguably one of the most important sources of the UK constitution. And really, it is one of the sources of the UK Constitution that is indicative, if you will, of the nature of the United Kingdom as an uncodified system of constitutional law. And so the idea here is that we're going to talk a little bit about the nature of the Constitutional Convention, what a convention is, how it is defined in a way, and then we'll talk about them in more detail in future lessons time, how they're formed in future lessons time, and then maybe the different kinds that you will be familiar with. So, what is a constitutional convention? Well, we can define a constitutional convention as follows. Generally speaking, and simply put, a constitutional convention is considered to be a general rule of thumb where there is seen to be some kind of obligation that an individual has to follow. That is essentially what a constitutional convention tells us. That's what a constitutional convention is. This is an obligation that is not born out of legal enforcement. So it's not that you are legally enforced. You have to, or there is a legal enforcement against you if you do not follow the convention. But it is seen to be a general rule of thumb which seems to have with it some kind of obligatory standard, obligatory connection to it. And so ultimately, this obligation to follow the Constitutional Convention is not born out of legal obligation. So if you were to break a convention, you do not get a prison time, or you don't get a fine, or you don't get any kind of legal charge against you. It was A.V. Dicey who first expressed the idea of constitutional conventions as existing in the dichotomy between the legal and the non-legal sources of the UK's constitutional framework. John Stuart Mill described them as, quote, unwritten maxims. And these are, generally speaking, good ways in which we can define what a constitutional convention is. It is an unwritten maxim. It is something that is seen to be a general rule that we all follow, but that there is no legal obligation to follow. The following of the convention is to essentially ensure the proper working of the UK's constitutional framework. So, according to A.V. Dicey, who was, of course, a very, very prominent figure on the area of UK constitutional law, a constitution is a collection of understandings, habits, or practices which, though they may regulate the conduct of officials, are not in reality laws at all, since they are not enforced by the courts. This is a constitutional convention according to A.V. Dicey, and as cited in Popworth from 2020. And so as a result of this, we can see essentially the two key characteristics of a constitutional convention. The first characteristic of a constitutional convention is that it is a rule that people follow. It is a rule that is generally adhered to by everybody who it is applying to. So if it's a government constitutional convention, then it will apply to government ministers, for example. And it regulates conduct. That's sort of part of the first element, the first idea of a constitutional convention. The second element of a constitutional convention is the fact that in reality, they are not laws and they are not enforced by courts. this gives us the second principle of constitutional conventions. While some will pick up on the latter part of this passage and argue that certain elements of constitutional conventions may be enforced by the courts, this description by A.V. Dicey is particularly apposite. And you can probably imagine, though, that the idea of a constitutional convention is one which has attracted a lot of debate among academia as well as by constitutional theorists and constitutional scholars. Because they are not enforceable by courts, they are not clearly defined positive law, then we have this sort of wishy-washy concept that we have to describe and we have to think about and formulate as part of the broader constitutional framework of the UK. According to Barber from 2009, constitutional conventions and laws are two brands of social rule which differ in the extent of their formalization. Laws and constitutional conventions behave in similar ways and share many commonalities or many qualities. And this gives us rise to a major question here, which is the idea of the different categories of constitutional convention. Now, what we'll do in the next lesson is explore the various types of conventions which exist. We won't cover all of them because there are a non-exhaustive list, essentially, of constitutional conventions, and so as a result of which we could be here for hours describing each of the conventions, but we'll explore some of the most important ones and some of the bigger ones that you may encounter throughout your studies of constitutional law. But for now, it should be noted that there are different categories that can be listed. We can talk, for example, about constitutional conventions which may regulate the relationship between the Prime Minister and their cabinet. We can talk about conventions which regulate the relationship between the two houses of Parliament. We could talk about constitutional conventions which regulate relationships between the legislature and the Crown, ministers and the civil service, etc., etc., etc. So an example of the first category, Prime Minister and Cabinet, you can think about the concept of collective ministerial responsibility. This being a major constitutional convention that essentially a cabinet ought to show a united front on policy decisions, even if the people in question do not necessarily agree with the measure being imposed. The relationship between the two houses of Parliament, one that we have already spoken about, is known as the Salisbury Convention, which is the convention that says that the House of Lords cannot and should not be striking down legislation that is and forms part of a government manifesto pledge. You also have the relationship between the legislature and the Crown. Technically, the royal assent, giving royal assent to legislation, is a constitutional convention, and so as a result of which it regulates the relationship that the Parliament has with the monarch. So some of these are really, really easy to understand, some of them are a little bit more complicated, and we'll get to some more examples in the next lesson.